2020 presidential elections no omon famra court na afafa ni nyina atimi ahwehwem ahwese enkrata ni nyina dimu a bibia ededa nakwam enti eno ho arguments enenne ye lawyer Chachuchi Kata eye ya muti bi no na asem wo kan ye ne tofabo mu nyina ne se sa documents aye ka ho asemi se court no anhye electoral commission for amoma ma court ama ya anhwehwe mu a enya de a atentene ni betumi aye adwuma na yatumi ehu emma dodo a epiem e wo 2020 presidential elections ni mu na senti okasa ne se yakoto abato baako de bia da yete results for on 7th December 9th December Jimensa or returning officer or declare results no the figures be two dra mote say oboso or the total valid votes or the two dra in that declaration you know 13,434,574 kwansima ade achen ya na mami asanso asesana no e the figures for fraba the room 13,433,573 after the total valid votes in the crown another figure 13,119,460 ye be pie court so a no wasanso the figure for fraba so figure original so they declare abanama man penye kufuado no say there 13,121,111 let's say according to lawyer Chachuchi Kata no figures no adoso ye nim de documents in krata isi agina so the figures we nyina eba it is a atentri ni ntini aba court no krenti ni aba court na ye pese pere yo ye adwuma de a ene ni die mu na osrese court no be hye isi na omode san krata na ba na ye nyina yetimi ahwehwem na sa request isu se bio enya no krese eye ne ya na o make sa request na te se de ye nuanom e kan ye or yes, our request no true idea your friend mutual discoveries as far back as 19th January. Senka we there e ma court to crumple mam ya ho no mpenyufo so utimu fitati am wanku it is a when you boni bia dia ma yen hwe wo documents a wugina so dey sa figures ahodo nyina bai but the name say EC4 anti asienti enene wode service ade ebeto court no enim court no de na temu bai de mo kan ne say omo ne anya adwen nti enya de omo be hye easy ama omo de sankrata no abakot amayahwe because sa documents are ye pese easy for the bano ye woni nyina emra ne say at every level of the election process and I was say ye be my agents na ehọ ena nidie mu ye ne court no enya adwen esan say we hwe adanse a eda court na nim na bibia chirepefe say documents no bebre wo ha NDC for ye ni bi for example document a your friend form 13 enra yura Dr. Kwesa White adanse mu ehho ba asem wo be hwa judge ba ko e de sa form ne kire no e sa form no e na Jimensa na electoral commission for say omo wi abato ne ho adwuma nyina wie ye no omo record ma wo bi anya ye wo so ma agency nsan ye na wo Dr. Kwesa White adanse mu te say wo kire mu say some running poor no more yes are now more as agents no money ho because na Jimensa dada omo amomo free was omone the flag bearer of NDC kwa kodin kita ho bi it is out from 13 no omo ndi kosua say enhu bi yamfa omo krompo na campus o maka say yen sign na ye reason ni enti omo ni bi and for that matter NDC ni bi enti hot ye ni biemu ye ne court ne nya adwen say documents are yebisa ye nyina ye will be because clearly no ye need from 13 whether duplicate or original ABM it can be correct to say oh pink sheet polling station will be constituency summary sheet will be regional coalition sheet will be yes but ye nyina de ye nyina ye will be ye declaration we on the 9th no and wechi Jimensa no kwa ne isifo akwa kwhye kokuom asesa no ensesa omo ye nyina no so no ye gidi se ejina nkrata bi so omo sesa ne wie no omo sanso akosesa ne biem omo sanso akosesa ne biem enti enkrata omo gina so de sa different figures na ba ne ye ni bi enti sa wo kasa ye wo documents ni nyina adenti ne ye sanso bi sa omo a na ne biemu ye ne wonya adwen because the foundation documents for the different figures they have churned out are not in our possession. It is a Nissan Kratana, a Sidane, now we who say, we near Krata papa, easy for you see, and away your papa. Not the Krato. Ubekaya Eastern region, collation sheet and one basem. Collation sheet na koyemunu. Nina easy for the almost ashas. But easy for watch, bako ye papa, bako ye papa. Say easy for emphasize our originals now, or modia or declaration and all the corrections now. Is it then NDC which of these two documents the EC used for declaration ye challenging? It is not the case, it's NDC for ye near dance ye be an yaba court, ye ba be. But yen yaba court, ye no crania and training the person ye juma. The Electoral Commission and the motu, transparency, fairness, and integrity. Now, no, SCS, why about to be the other of my Mampenia Kufuad Arena. Now, if Fankrata, Ujina so de who saw Mampenia Kufuad Arena, Brand Yen was a member for when you could see Ampunia Day, and share. To where I am Seba, ye be Jayamagana for Nam Wankasamobua. By yet, ye would Gidia Mapase, no crack away a yabacope. I saw Yamiku Krukuita to we. No crack was same way be a mono, whether or not this application has been granted or refused. And if you court the Asha say I'm right, Basso. You heard him say a sans on the movie share. Madame Must say, Samobay, thank you.
So, colleagues, shall we go? Shall we go? All right, so good afternoon, and thank you for giving us some time to share with you a few of our thoughts after proceedings were adjourned today. Right from the onset, let me give you a little narration of the background so far. We have been in court because a petitioner, Mr. John Dramani Mahama, has invoked the jurisdiction of the Supreme Court that, among other things, upon a proper reckoning of the December 7, 2020 presidential election results, no candidate achieved above 50%. And therefore, the declaration as made by the chair of the Electoral Commission is in breach of Article 63, Clause 3. And from the onset, he indicated in his petition that he will be calling 5 witnesses who will be adducing evidence before this court to prove that indeed nobody got 50% plus 1. On the first day for his first witness, Mr. Johnson Asiedun Ketia, you all observed how, upon cross-examination, upon various scenarios, he kept coming to the same answer, 47% for the petitioner, 51% plus for the second respondent. We were informed that he intended to put a second witness in the box who adduced further evidence that nobody crossed the 50% mark. Dr. Kwesa White was put in the box yesterday. The crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the government of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed, it was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days. after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation. But it is not a matter that you have as of right. It is at the discretion of the court. And you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents because, among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchikata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there's anything wrong with the copies that he has, and therefore asking to inspect the originals. Because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent. And they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity that must be met. And that indeed, on record, they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today. And if you look at section, I think 166 of the Evidence Act, they have not raised issues of authenticity even. And therefore, it is not the 1 hour, submissions and English that would invoke the court to exercise its discretion in this matter. You must ground it in law and prove same. We are of the view that the pendulum swings back to the petitioner, who had advertised that he has 5 witnesses who will give evidence to show that nobody got 50%. We've heard the first 2. The jury is out on that one. If there are 3 other witnesses, now will be the good time for them to either submit those witnesses to adduce this evidence that shows they are supporters that they told they had won and then they came to change the story, but that will show them that indeed nobody won. Or if they are not able to put further witnesses before the court, then they would have to bring down their case, and then the respondents will also have to now move to their next line of action. We think it's generally been a good day in court for justice, and we look forward to the directions of the court on Friday.
So, Mr. Minister Designate, Mr. Kojo Ponkroma, two questions. The first one is that we've noticed that in court, most of the time, the petitioner's side is doing very long arguments, whereas the respondents, both you and the EC side, do very little arguments. What's accounting for this? And again, every time we've come to court when there's an adjournment, the Chief Justice will indicate what will happen next in the next sitting. This adjournment, there is no such indication. Can you give us some indication as to what we should expect at the next sitting?
I mean, obviously, you saw the bench invite lead counsels into chambers and have a set of conversations with them. We were not in chambers. We were not privy to it. It was something that obviously they did not want to advertise in open court. I am sure that that has an influence on the adjournment and the directions for Friday, but we are not in a position to say because we were not in there. We'll look forward to whatever the Honorable Court will put out on Friday. But to your first question, yes, as a matter of fact, you notice that counsel for the petitioner sometimes has about an hour. In fact, today you noticed from about 9:30 something to about 10:30 thereabout on his feet making arguments. And counsels for first respondent and second respondent are very crisp in their responses. It is because this is a court of law, not a court of public opinion. When you make an application before the court, you must satisfy what the law requires and back it with authorities that are relevant or the legal invocations that are relevant. For example, if you recall the application for leave for supplementary, counsel for the petitioner was on his feet for several minutes, but if you listen to the ruling of the court, it says that even the authority that you cited, Elis Tamaklu, has nothing to do with supplementary applications of this nature. And the expectation that you will give us good law to back your application did not happen. So we are not invoked. Counsels on our side, you would notice, are limiting themselves to the law and the legal requirements, are not necessarily arguing with the bench, and are speaking to matters of law. So what does the law say? That is what we are interested in arguing. So if under CI 127, under Rule 44, there's a clear provision that forms are set out and must be made available to all parties. All we need to do is to invoke that. We don't need a lot of grammar to make our case. And that's why you would have noticed that we are not spending too much time speaking English, but we're speaking law.
Understand how we get when we don't get the information we seek. So, follow up to his one of his questions. Do you have and can you help us with any indication as to what would happen on Friday when the court reconvenes? I
cannot, because as I've mentioned, we were not in chambers with the judges. We are expecting, and if you look at the natural flow of this case, we're expecting the petitioner, because the law says he who alleges must prove. The petitioner has told us that he has 5 witnesses who will prove, among other things, that nobody got 50% and that we should go for a runoff. Not so. The petitioner has put 2 witnesses in the box who have been cross-examined. We are expecting that the petitioner ordinarily will call the other 3. The petitioner today brought an application which was filed just in the last 48 hours, which application is what has consumed our time. And our expectation is that the petitioner will either continue with the 3 other witnesses or inform the court that they intend to bring down their case at this point for the respondents to now also move whatever submissions that they may have. Intervening in these 2 is this new application that they brought, the chambers hearing, and the direction that we should come back on Friday. So we'll wait on Friday and hear what the court has to say.
Mr. Minister Designate, the petitioner spokespersons said that they don't have copies or carbon copies of this Form 13. May I know if you have one and why they don't have one?
So you should listen clearly to the court. You see, sometimes when we come to court, it's not what counsel on our side says or what counsel on the other side says, because lawyers and witnesses can say so many things. In the end, it is what the court finds. And if you heard the court clearly, the court started off by invoking CI 127 Rule 44, where copies are made available, and proceeds to say that the court is clear in its mind that all of those documents are available to the petitioner, and I dare even say by extension, to all other parties who participated in this election in accordance with the law. That's been the very clear finding of the court and ruling accordingly.
Mr. Ponkroma, your side has always held from the very beginning that...
I'm sorry, I can't hear you very
I'm
well.
saying your side has held from the very beginning that the petitioner has no case. You have told us that they've gone through their witnesses. They finished with two of their witnesses who provided two witness statements. You also cited the High Court procedures of how when applicants make a case and they send witnesses through and they are done, what happens next? Will your side file a submission of no case on Friday or going forward?
Well, they have not, in our understanding, completed making their case. They have only called 2 out of 5 witnesses. The first one is the one who came in ostensibly to suggest that nobody got 50%. But you saw this witness always calculating and getting 47.51, 47.51. The second one, who you thought was also coming to provide evidence that nobody got 50%, came in only to say that he heard through Rojo Metilnuno that they were instructed to leave, and later admitted that nobody had power to instruct them to leave. As to how that accounts for nobody won 50%, I'm not sure. They have 3 other witnesses that they have informed the court they want to call. So it is at the end of the making of what is ostensibly their case that respondents will take the next line of action.
My right honorable, primarily the court asked.
I'm sorry, I'm struggling to hear you, sir.
My right honorable, good afternoon. Primarily the court asked for more details from the plaintiff, the complainant, that the case was adjourned to the 27th. Now, have the details, all the details, been supplied? And is that the reason why there's an adjournment to Friday for a decision? And if all the details have not been supplied, is there a reason for an infraction for continuity at all in this case?
As I've mentioned, I cannot guess the purpose for the court's order of adjournment. We are in the hands of the court. We'll come back on Friday and hear whatever further directions they may have. I want to thank you. After one more question, and then I would invite my colleague to wrap up in 3.
Honorable, this morning, the lead counsel for the petitioner asked a question in court that if the EC's interest is in transparency, then why is this so difficult for them? Indeed, you have on several occasions spoken about the public opinion that the lead counsel for the petitioner appears to